Assalamualaikum warahmatullahi wabarakatuh. My name is Nura Shawika binti Zulhani and my matric number is H21A2321. So today I will present about the nature information of the company. So in the nature information in company, there is a member have limited liability. However, the company may be formed with unlimited liability of member, or members may guarantee a particular amount. Section 3 of the Company Act 2050 defined as a company mean a company established and registered under this act or an existing company. At common law, a company is a legal person or legal entity separate from and capable of survive outside the living of its members. In addition, there is also the concept of a business corporation emerged during the Mercantil era mainly for two reasons. First, the need for large-scale investment consistent with market demand as a result. Traders are in the dire straits require a commercial device that can be facilitate the generation of capital on a large scale. Second, need to limit investor liability. Member contribute money or money's worth to common share. As a legal entity, the nature of company is that it only has the power conferred on it by its memorandum of association, which is the company character. That's all for me. Thank you.
My name is Nur Hanifah binti Ahmad Lazim. My matric number is H21A2422. I will talk about company law. This is the study of the rule and principle which regulate the operation of what Kenya law recognizes as a company. We have three sources of company law. First, Company Act 2050. This is a law passed by the Kenya legislature and it began effective in 2050. The UK 2006 Company Act was significantly reversed in the new act. The new act is by far the largest piece of a law on Kenya state book with 1026 sections and more than 1,600 pages. Secondly, is common law and doctrine of equity. When used to compare the English legal system to other legal systems, the phrase common law can also apply to the English legal system as a whole. It may also be used to refer to the legal principle that the English legal system have developed through time as a result of judicial precedent. Thirdly is precedent. When they come from the Supreme Court, these judgments rendered by Kenya highest court have the same legal force as those rendered by the High Court and are also binding on the Court of Appeal. When it comes to how business law should be interpreted, Supreme Court rather serve as a guidance for lower court.
Assalamualaikum, my name is Siti Tiara Shazira binti Jahinda Alam and my matric number is H21A2699. Next, I will explain about the type of company. There have 5 types of company. First is chartered companies. Companies that have been given a chartered or letter patent by the Crown, which bestows corporate personality, is described as chartered company. Organization with philanthropic or charitable goals such schools, college, and Society for the Art and Learning frequently use this business. Under Kenya's University Act Chapter 210 laws, private universities are corporations with charters. An application for a charter must be submitted to the Commission for Higher Education, Cabinet Secretary for Education, and President in order to start a private university. The university's name, membership, authorities, and duties must all be specified in the charters. When a private university charter is made public in the Kenya Gazette, it acquires legal status. Second is statutory companies. It is those that the government has created through specific laws to give them authorities that the Business Act does not provide. These businesses are intended to run properly and in accordance with commercial principles. They do not have shareholders and receive their intended funding from the Treasury. Their property may be attached by creditor if they are success, but cannot be wound up at the request of creditor if they are unable to pay their debt. Public body and organization established by Parliamentary Act, including the Agricultural Finance Corporation and Kenya Railway, carry out duties. Statutory firms have the legal status of individual and are corporations with defined purposes defined by the legislation established them. They can only wind up on the repeal or revocation of them specified at the created them. That is registered companies. A Kenya registered company must be created by registration at the registrar's office and be registered under the Companies Act as described in Section 3 of the Act. Next is corporations. So it is a legally established office with limited liability, perpetual succession, and capacity to contract, own property, and sue or be sued. Example include the public trusted and principal secretary to the National Treasury. Lastly is corporation aggregate. It is a legal entity formed by two or more individuals for a lawful purpose with limited liability, contracting capacity, property ownership, and perpetual succession. Example include public and private companies.
Good afternoon, sir. My name is Aliza Anabujang, matric number H21A2786. Today I will present about nature and characteristic of companies. A company is an artificial person, a person created through a legal process. It is an abstraction of law often described as a juristic person. It is a metaphysical entity created in contemplation of the law. They have 7 characteristics of companies. 1 is legal personality, 2 limited liability, 3 is owning of property, 4 is sue or be sued. Number 5 is capacity to contract. Number 6 is perpetual succession. Number 7 is commensurate. That's all from me. Thank you.
Assalamualaikum and hi. My name is Siti Nurfatia binti Zamri and my matric number is H21A2675. So I'm going to present about classification of companies. Companies that are incorporated under the Companies Act of 2013 or the Companies Act of 1956 are considered as body corporates. Private company and public company are the two main categories. Since many additional types of companies are included in the Act's definition, this information is rarely noticed. Firstly, Section 5 of the Companies Act analyzes if a company is limited by shares or by guarantee and classifies it as a limited company. Section 6 provides that if the articles of incorporation of a company limit the members' liability to any amount owed on the shares they own, the company qualifies as being limited by shares. Next, Section 7 provides that a company is a company limited by guarantee if it does not have a share capital. Second, if the articles of incorporation of the company limit the members' liability to the amount that they agree to contribute to the company's assets in the case of its liquidation. And third, if the company is described as limited by guarantee in its certificate of incorporation. While Section 8 provides that a company is an unlimited company if there is no limit on the liability of its members and if the members' liability is unlimited according to the company's certificate of the formation. Section 9 provides that a company is private if its articles restrict a member's right to transfer shares, limit the number of members to 50, and stop the public from receiving invitations to subscribe for the company's share or debentures. Section 9 also provides that a company is private if it is not a company limited by guarantee and if it is described as a private company in its certificate of incorporation. Last but not least, Section 10 provides that a company is a public company if the company's article give its shareholders the right to transfer their shares of the company. Second, if its article do not prohibit invitations to the public to subscribe for shares or debentures of the company. And last, if it is a public company, as stated in its certificate of incorporation. That's all.
My name is Petrusana Amintag and my matrix number is H21829773. For principles of legal personality and field of incorporation, legal personality is a business that has been established and registered in accordance with the Act, becomes a legal entity that is independent and apart from its owner and management. It develops a separate existence with certain abilities and is vulnerable to limitations. For veil of incorporation is a business that is a legal person who is separate from its members according to the usual norm. Between the corporation and its member, the principle is thought of as a curtain, veil, or shield shielding the latter from the obligation of the former. Next, the veil of incorporation can be lifted either by statute or by common law. For the lifting the veil by common law, first is agency. Agency, in order to hold one organization accountable as a principle for the action of another, the connection of agency must be firmly established. Second, ratification of corporate acts. In the past, a firm would only be obligated in a situation that would otherwise be illegal with the majority approval of its member. It is clearly obvious that unanimity is not required. A matter does not have to be approved by all of the company's members. Third is fraud. The common law has consistently and again stated that the veil of incorporation will be removed to stop members of a business from engaging in fraud or unlawful design. This is often done to stop people from utilizing the benefit of a company formation to willfully and knowingly further fraud, unlawful crimes, or inappropriate behavior. Fourth is the determination of resident. Lifting the veil of formation is required to determine a company's resident. This is so because a firm is considered to have a resident in the nation from which it controls and manages its activities. Fifth is the determinate group enterprise. For group enterprise, the court has frequently ruled that a parent business and its subsidiary are the same legal entity and vice versa. And then next, the determination of character. A firm has no real personality since it is an artificial person. It is neither an ally nor an enemy. It cannot be both obedient and disobedient. For the lifting the veil by statutes, first is non-publication of a company's name. Officers and other agents of a company are required under Section 67 of the Companies Act to sign the company's name on its seal, letters, business papers, and negotiable instruments. Next is the investigation of company's affair. The authority to look into the affair of a business subsidiary or holding a company is granted by Section 787 to an inspector appointed by the court to look into the company's affairs if the inspector determines that doing so is essential for the purposes of his inquiry. Third is this investigation of company's membership. According to Section 801, the Attorney General may designate one or more qualified inspectors to look into and report on a company's membership. And last but not least, is takeover bids. According to Section 599, the Capital Markets Authority may impose penalties on anybody who disobeys the takeover regulations or any instructions. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Hana Fazlina binti Jacoinizan and my matric number is H2NA2059. In conclusion, common law is a company that legal person or legal entity separate from and capable of surviving outside the life of its member. Like any legal entity, a company is legally an entity apart from its member, with right, capacity and obligation of its own, and endowed with the potential for continual succession. However, a company is not just a legal institution, it is also a legal duty to achieve any social or economic purpose and largely has public and social responsibility. Thank you.